The content of the following program, including all statements from the host and guests, is to provide general information and commentary about the law. Under no circumstances does any statement made by a host or guest to a caller or listener constitute legal advice or the formation of an attorney-client relationship, and the material from this program should not be viewed as a substitute for personal consultation with an attorney. Welcome to Talk Legal with Jeff Van Treese, who brings you all the latest news in the legal world. Jeff will be discussing a variety of legal topics with experts in the field. If you would like to ask a question or share a story on the air, please call toll-free 888-565-1470. Once again, that's 888-565-1470. Now, let's talk legal with Jeff Van Treese.
Good evening and welcome to another edition of Talk Legal. I'm your host, Jeff Van Treese. I'm an attorney with the law firm Oltman, Flynn & Kubler, where we practice intellectual property law, including patents, trademarks, and copyrights. You can check us out online and view all archived episodes of this show on our website at oltmanpatent.com. That's oltmanpatent.com. I have a very special guest in studio this evening. His name is Elliot Kula. Elliot is a board-certified appellate lawyer. He practices in Miami, down in Aventura, and this evening we're going to be talking about the appellate process. It's the first time we've discussed that on this show, and also talk about some appellate cases that are in the news. So, Elliot, I'd like to welcome you to the show this evening.
Thank you, Jeff. It's a pleasure to be here.
So tell us a little bit about the appellate process. This is kind of shrouded in secrecy. We hear about some cases on the news, but if you could just give us a brief overview of when a case might go to an appeal.
Well, the appellate process is different than the trial process because in the trial process, the judge there's a single judge who's making a decision in the first instance on a case. When it gets to the appellate process, that ruling is reviewed. That ruling is reviewed by a panel of 3 judges generally. There are some instances where it's a single judge, but generally it's a 3-judge panel in the intermediate appellate court, and it's a reviewing process. It's not an administering of justice process. It's a reviewing process to make certain that the administration of justice was done correctly. And that means both that the process was done properly and fairly with all notice to the parties, to the litigants. And then at the same time, there's the merits review, which is, was the proper law applied? Was the proper law applied correctly?
So really the question that is usually coming up on appeal is the question of whether the trial judge did something wrong. And then, of course, there has to be some sort of decision as to whether the trial judge's error, if there was error, actually prejudiced the party, because there's such a thing as harmless error under some circumstances.
That's exactly right. Harmless error. And actually in Florida, harmless error has taken on a new life recently with the Florida Supreme Court decision. And it really, you look at that the decision that the trial court made and determine whether or not it was error, and then you decide, did it really matter? Did it really influence? But for that, would have there been a different outcome? And the appellate courts now, in light of the recent Florida Supreme Court ruling, one of the parties was special, so we call it the special decision, dealing with harmless errors, really made that an important element of the appeal now. And it has made it so that if you are the appellee, in other words, you've prevailed in the trial court, that's now an issue that you have to wrestle with, and no longer can you sit back and put your feet up and smoke that cigar just because you won in the appellate court, because the burden has shifted, and you have, as the appellee, to show that that error was harmless. That's the big shift with the harmless error analysis, by the way. It used to be a burden that was on the appellant. Now the burden is on the appellee to show that it was not harmful.
And the appellee is the party that won at trial.
Correct. So here you are, you've prevailed in the trial court, and you have your $1 million judgment. The other side is appealing, and all of a sudden you find, instead of just having to say, well, everything was fine in the trial court, don't worry about anything appellate court, now all of a sudden you have to say, everything was fine, and let me explain to you, appellate court, that anything that went wrong wasn't even harmful. And that's an added burden that the appellees did not have until the special decision earlier this year.
Now, one of the things that you mentioned is there's a 3-judge panel most of the time when you're going from circuit court to the District Court of Appeals, and we have multiple District Court of Appeals throughout the state of Florida. And the next step after that is the Florida Supreme Court. On the federal side, it usually go from District Court to Circuit Court. Is that an accurate description of the appellate process?
That's quite accurate.
So, but now there's some circumstances where if you have a small dollar amount at stake in the original trial, it might go from county court to circuit court, and it never actually gets to go to an appellate court. It's simply going to a judge that normally hears trials, but they're going to be hearing an appeal coming from a county court in a particular instance. This can have quite significant ramifications.
It absolutely can. And so the circuit court and the county court, those are our trial courts in Florida. And depending on if it meets the jurisdictional amount, the amount that's necessary to put yourself into circuit court or not, and there are certain areas of the law, there are certain claims that must be brought in a county court, like a landlord-tenant dispute, for example. So when those county court cases are resolved, you would appeal to the circuit court in acting in an appellate capacity. If you're in those situations, you might often find yourself in front of one judge on review, and that's really just a practical matter. If you're appealing from a county court to a circuit court that's going to be acting in its appellate capacity, and you're in one of those smaller circuits in Florida, not Miami-Dade County Circuit Court, our 11th Judicial Circuit, or even Broward or Palm Beach, but one of the smaller circuits around the state, they might not have enough judges to have 3 judge panels, so you end up with one judge. That creates a very different dynamic because you have one judge reviewing one judge, as opposed to the cases where you have a 3-judge panel, where you have 3 judges reviewing one panel, and then you have that interplay between the 3 judges discussing what happened. And 3 judges, the thought is, are more inclined to discuss and consider whether or not the single judge did something wrong. And there's something atmospherically about sitting in 3s where you are more inclined to review as opposed to the 1-to-1.
And this is significant because, like you said, certain types of cases, like landlord-tenant cases, have to be heard in county court. So you'll never get that 3-judge panel if you have to appeal. And this is important because there's a certain level of confidence that you have just in having the 3 judges. The other thing is that if you're in a district court of appeal, that ruling gets published, and the whole world can see it. And all of the other lawyers in the state that come up with similar circumstances might have an opportunity to look at that case. So there's going to be a certain amount of pressure on the District Court of Appeals judges to get it right, because they don't want to be publishing bad law that's going to become known to the world. But if a circuit court rules incorrectly on appeal, that doesn't get published, and that's never known to anybody.
That's right. And there's another element to that, is that a circuit court sitting in its appellate capacity, 2 things to keep in mind with that. First of all, that judge, or even those 3 judges that are sitting in appellate capacity, they are trial judges. They spend their entire day in the trial court acting as trial judges. So when they have to switch hats in the middle and act as an appellate judge, there's first of all just a scheduling issue. They're not in a position to take 8 hours away from their judicial responsibilities and say, I'm going to study this brief and I'm going to study the case law that is applicable. It's harder for them. It makes it really a long day when they're sitting in the trial court all day and then also having to hear oral arguments and handle an appellate caseload. It's just a lot of work. The other thing to keep in mind with the Circuit Court Appellate Division is their decisions, as you alluded to, they're not binding. They're not binding in the same way that an appellate decision. So if the 3rd District Court of Appeal or the 4th District Court of Appeal, which governs Indian River, Martin, St. Lucie, and down in through Broward, when they issue a decision, that decision is binding on the trial courts. And that court, the 4th District Court of Appeal, cannot issue a decision that's in conflict with another decision of the 4th District Court of Appeal. So there is a lot of different sorts of pressures in that decision-making process. The Circuit Court Appellate Division issues the decision. It's not binding on any other circuit judge who may act as an appellate judge. It doesn't have that same binding effect.
Now, very few cases ever actually make it in Florida up to the Supreme Court, the Florida Supreme Court. Usually a case will end at the District Court of Appeal level.
That's correct. In Florida, we refer to the District Courts of Appeal, and as you mentioned earlier, there are 5 of them around the state. Those are courts of last resort in Florida. That's where you get your right to an appeal of a final order, and that's it. There's no guarantee, there's no right to go to the Florida Supreme Court except in certain instances. And those are limited. Generally, we'll see those death penalty cases go up to the Florida Supreme Court. In fact, those go up directly and skip the intermediate appellate court. Where the appellate court declares a statute unconstitutional, that's going to go up automatically for review in the Florida Supreme Court. But most of the cases that most of us appellate practitioners see out there, the way we get to the Florida Supreme Court is we are able to make an argument that the 4th District Court of Appeal issued a decision that's entirely consistent with 4th District Court of Appeal precedent, but conflicts with something the 3rd District Court of Appeal has said on the same point of law. And that's where we get to the Florida Supreme Court to resolve that conflict. And by the way, it's not a matter of right, it's a discretionary call. And sometimes the Florida Supreme Court will say it's not a conflict that we can't live with, and they'll let it go.
And with the discretion that you're talking about, that plays a huge role because the court can determine how many cases it takes. That's, in fact, one of the principal roles that the Chief Justice, and for example, in the United States Supreme Court, the Chief Justice actually controls the docket. And so we look at the Chief Justice now, John Roberts, and you compare him to Rehnquist before that and Warren Burger before that, and you see that John Roberts is taking more cases compared to his predecessor, Rehnquist.
That's correct. Now, Florida is a little different. Florida, the justices determine collectively whether or not to grant review, that discretionary review. So you file your notice in the appellate court announcing to the appellate court and to the world that you're taking this decision and you're going to bring it to the Florida Supreme Court for review. Then you have to file your first round of briefs in the Florida Supreme Court, a jurisdictional brief, which is a short 10-page brief, limited only to what's in the opinion that you're bringing to the court for review. And you have to make your argument in that 10 pages. This case conflicts with another case, and therefore the Florida Supreme Court should accept the case and resolve the conflict. Once that case is accepted for review, then you actually get to brief the actual merits of the appeal and argue the issues. And by the way, sometimes the Florida Supreme Court will say, after taking a case on discretionary review, then reviewing your brief, the Florida Supreme Court might say, we've now had second thoughts. We don't think this is a conflict that we need to get involved in. So it is very difficult to get to the Florida Supreme Court.
I can imagine. You mentioned, well, we talked before the show, you worked in the appellate division of the Attorney General's office, and you've seen some death penalty appeals. We always hear about some of this in the news. If you could just explain sort of what is the general process in a death penalty case. They are unique in terms of how the appeal progresses.
They are unique, and in fact, the Attorney General's office for Florida there's separate divisions even that handle the death penalty cases. Because it is highly specialized. There are concerns that go beyond the appeal because there are additional rounds of review. First thing with the death penalty cases is they are reviewed by the Florida Supreme Court on direct appeal from the sentence and conviction to the Florida Supreme Court. By the way, the Florida Supreme Court, a majority of its docket is occupied with death penalty cases. Once that appeal is done, then there are avenues to go into federal court. There are also some additional avenues in state court, going back to the trial court and asking for post-conviction relief. You can have appeals from post-conviction relief that get you back up into the Florida Supreme Court. Or you end up in federal court and you have federal petitions for habeas corpus, and you run through that process, and then you end up in the Florida Supreme Court.
What is habeas corpus, if you could define that?
Habeas corpus is literally means delivery of the body, and that's where there's a wrongful incarceration. You file a petition for habeas corpus to deliver the body from incarceration. So a death penalty case, unlike a general conviction, a death penalty case can go up on appeal several times from different trial court proceedings, from the original conviction and sentence, from a motion for post-conviction relief, from a petition for habeas corpus. It can end up in the Florida Supreme Court. It can end up in 11th Circuit. You can end up in the U.S. Supreme Court. There are a lot more appellate reviews, properly so, as there should be because of the seriousness of what we're dealing with. but it's a much more involved appellate process than someone who's convicted for a crime that involves incarceration. In that situation, you have one appeal to the District Court of Appeal. Like every other appeal, if there's conflict, you can go to the Florida Supreme Court for review, and then you have a post-conviction motion. But that's about it. It's a much more streamlined process.
And that's interesting because the death penalty is often advocated as a way of saying, well, we shouldn't be housing these horrible people for all these years, but it actually costs a lot more money to try a death penalty case, given the appellate process, than it would be to not have the death penalty.
That's correct. That's correct. And the death penalty cases and criminal cases in general, I find, are very highly specialized, and those are best handled by someone who specializes in criminal appeal. So I'm board certified in appellate practice. I have a general appellate practice covering all sorts of areas. When it comes to criminal cases, I generally have one of my colleagues who specializes in those types of appeals handle it.
So what do you think about the Tsarnaev case? He was recently convicted and sentenced to death in the federal courts. There's going to be some issues coming up there. You were talking earlier about the procedural defects that can be taken up on appeal. With Jahar Tsarnaev, there's an issue with respect to his Miranda rights. He was not read his Miranda rights when he confessed to the bombing, and that's something that's probably going to come up. They tried to use what's called the public safety exception to the U.S. Constitution, which the Supreme Court ruled that if there's a public safety emergency situation where the police have to get information very quickly for public safety, then they don't have to read the Miranda rights. But some commentators, including Alan Dershowitz, for example, have come out and said that that's just a pretext. They were just trying to get him to confess. It really had nothing to do with public safety. This is probably going to be one of these issues that goes up and up and up into the appellate courts and continues to do so for the next 20 or 30 years.
Right. And that in this case, obviously, is a very significant case and is going to bring attention to the issue in a way that other cases haven't. But it's a fairly routine issue that comes up often. And we'll see in the criminal context, I saw this a lot as an assistant attorney general, where the criminal defendants would actually enter a plea and reserve their right to appeal. And the only issue they would raise on appeal was whether or not they were given read their Miranda rights, or whether or not the search of their car was a proper and authorized search. And if they can exclude the evidence because of an improper search, and if they can avail themselves of that relief, they can undo a conviction.
And it's when we see the legal process portrayed on television, such as Law and Order and CSI, it sometimes makes it seem like it's very easy to get a case overturned on appeal, but it's really not. There's a very strong presumption that the trial court was correct, and like you said, if it's or even, for example, some of the examples you gave, but also you have ineffective assistance of counsel. That's a very tough burden to show that you had ineffective assistance of counsel in any case.
It is. The statistics on reversal rate, somewhere in the neighborhood of 11 to 13%. Now, that's just a statistic overall. You start to look at cases in groupings, and the statistics could go higher. But generally, when you're looking at overall number of appeals filed, number of appeals resulting in reversal, the statistic somewhere is around 11 to 13%. One thing interesting to note with the shows we see on TV, and yes, it's not quite as easy as after a 15-minute break in the action, you're prepared to go argue your appeal in front of the 3-judge panel. It's a far more involved process. But one of the things that's interesting is a lot of those shows come out of New York. And so what you'll see in those cases are a ruling by the trial court and an immediate appeal of that ruling, and then go back to the trial court and continue the trial, and then an immediate appeal of the next ruling. Some jurisdictions allow for non-final appeals. In other words, an order that's entered in the middle of a case, in the middle of a trial, maybe earlier pre-trial, on an order compelling somebody to produce a document. Some jurisdictions are more lenient in terms of the appeals that a party can take. In Florida, it's very limited in terms of the non-final appeals.
Now, there is a requirement that's called preservation. In other words, if you're an appellate lawyer under normal circumstances, you can't make an argument to the appellate court that wasn't originally made by the trial lawyer to the trial court. And this is because you have to be appealing error. You have to show that there was some sort of error. I'm sure that's happened in your practice where you see an argument you'd like to make it, but it was never made at trial.
And that can be very frustrating. A good argument that should have been made that wasn't made, and so therefore you cannot make it to the appellate court. There are some exceptions if you can establish that it's fundamental error,
Right.
Which is one of those things that are hard to describe, but you know it when you see it, and it's so cuts to the heart of the case that it was a denial of fair process. Then you can argue it's a fundamental error, and even though it wasn't argued in the first instance, you should be able to argue it in the review process. Sometimes it's not just a matter of you didn't make the argument, but it's you didn't follow through in making the argument. In other words, a good example of this is where something happens at trial. Someone says something inappropriate, such as making reference to that there's insurance here. And that's an improper comment.
Or, for example, you might have a situation where somebody comments on the criminal defendant's exercise of their right to remain silent. And that can be problematic. That can be grounds for mistrial as well.
Exactly. So you would object. The court would sustain the objection. And then you would have to ask, as you just said, you'd have to ask for the mistrial and give the judge the opportunity to say, yes, we're going to cancel this trial and it's going to be a do-over. If the judge denies the motion for mistrial, you have one more step that you have to take. You have to ask the judge to give a curative instruction and to give an instruction to the jury, disregard that comment. And if you don't do that, then you haven't followed through in closing the loop on having the trial court do everything within its power to fix an error and then complaining about it. You can't complain until you've done everything you have to do to fix it.
This can be quite a quandary for some trial lawyers because, on the one hand, everything might be going well, and then somebody makes a statement that would harm their client's case. But let's say they don't want a mistrial because they like the jury. They like the way the jury's assembled, and they're afraid that if they have a mistrial and they have to do it over again, they might not have the same composition on the jury that they're looking for. And if they ask for a mistrial and they're granted one, it might not be what they want. On the other hand, if they know that judges generally won't grant mistrials unless there's extraordinary circumstances, so they'll just ask for a mistrial just because that's what they have to do to preserve it, like you said.
That's right. It is Hobson's choice. And the analysis you just went through is a conversation in our office that happens every day with trial lawyers. Should they object, or should they just allow the flow? Sometimes when you object to something, you're bringing attention to it, so you might not want to object. But if you don't, then you can't complain about a piece of evidence having been put before the jury either.
And that can definitely be a concern. We were talking also before the show about the issue of access to courts, and that's something that the Florida Bar and the Supreme Court of Florida has taken a special interest in.
Yes, access to courts is a very important issue right now for everyone. And in this age of electronic transfer of information, it's easier to do. There's no longer the difficulty and the secrecy of a clerk's office. Everything is electronically available, and that access is really important. So now lawyers have to shift how they practice. Clients are understanding more about the practice, which is wonderful. A client that understands the practice can participate in decision-making at a higher level than a client who has no idea what's going on. So with electronic filing, the courts now have all of their case dockets in most jurisdictions available to the public. You go on the docket, and it's a live docket. There's a little icon on the side of the document. It's an Adobe or a PDF file. You click on it, and you can open up the document. You can see what's going on in the case. That's also facilitated the review on appeal because no longer do you have to wait for the clerk's office to print up the 10, 15,000 pages of documents that made up the trial record, copy it, put it into a binder, and send it up to the appellate court. Now it all happens electronically. And it's easier to search.
That helps lower costs as well, because it used
Absolutely.
to be that you had to pay for the record to be prepared. And that was an issue, especially when you had people of limited income that might be having to fund an appeal, let's say a foreclosure situation or something like that, and they would have huge records that had to be prepared at hundreds or thousands of dollars.
It's also, Jeff, influenced the way we practice. and it's allowed for people to have different sorts of practices, because you no longer need office space to keep massive files. You no longer need massive copiers to generate 5,000-page appendices to your briefs. It's all electronic. So it's allowed for people to start practices, and allowed lawyers who wanted to explore different areas. It's really created access to lawyers in a way that the public didn't have before, because no longer do you need to go to just a large firm that houses a large number of lawyers. There's room for small firms now in a way that didn't exist before, and to function at as high a level as the big firms could function, and handle the same size cases even, because you don't need the paper. You just need a computer with enough memory and storage and ability to pull up those documents.
Yeah, there was definitely some growing pains as we transitioned into electronic filing, but overall, I think more people are getting accustomed to it, and it's starting to work out even for the smaller practices. The other thing you mentioned about open access to court files, this is especially true when you have high-profile cases that we see that come out. The court records are always open to the public unless they're filed under seal, in which case there has to be a showing that there's some compelling reason to keep certain documents confidential. But it's always been open to the public, but it used to be you'd have to go to the courthouse and look up a file and look at the physical copies. Now everyone can just get them online. So it's really made the whole litigation process more open to the public.
And that confidentiality that you had mentioned is really important now. And the various rules committee, the Rules of Judicial Administration from the Florida Bar, are crafting new rules to make sure that lawyers cleanse documents before they publicize them and post them to a docket, so that secret information, Social Security numbers, bank account numbers, are not made public.
We have about a minute left. I want to make sure you have an opportunity to give your contact information out to our listeners.
Oh, thanks very much, Jeff. Again, my name is Elliot Kula. My law firm is Kula & Associates. We have several lawyers in the office who handle appeals, and you can visit us at www.kulalegal.com.
I'd like to give another very special thanks to my guest, Elliot Kula. Please tune in next Tuesday evening from 6 to 6:30. This has been Talk Legal with Jeff Van Treese. Thank you so much, and have a great evening.
Thank you for listening to Talk Legal with Jeff Van Treese. Tune in next week for more insightful and exciting information about the law. You can contact Jeff by email at jvt2law@gmail.com or give him a call at 561-789-6866. That's 561-789-6866. The content of the preceding program, including all statements from the host and guests, is to provide general information and commentary about the law. Under no circumstances does any statement made by a host or guest to a caller or listener constitute legal advice or the formation of an attorney-client relationship, and the material of this program should not be viewed as a substitute for personal consultation with an attorney. The opinions expressed on the preceding sponsored program